What's up, everybody? Welcome back in to another episode of The Lawyer You Know. And we're back with Sarah Boone. I didn't think we'd be here. I thought we were done. I thought she finally had her appellate lawyer, even though it's appellate lawyer number 2, I believe, come on the case, conflict counsel, court appointed, paid by the state. But we're here because now he wants out. We're going to talk about why. We're going to talk about why Sarah Boone doesn't have an appeal filed. She definitely should have an appeal filed by now. So does this create some kind of issue? Is she not getting the appropriate counsel that she deserves? What does Sarah Boone have to say about that? Does she have some complaints? Well, all that and more on today's episode. And of course, we're going to answer your questions. Everybody buckle up because we're back with Sarah Boone. All right, let's start with where we're at in her appellate process, because when I saw all of this come to the forefront and you guys sending me all these articles, asking me all these questions, I was like, isn't her appeal filed by now? Why does this guy want out? What's going on? Like, what reason could he possibly want out by now? Just file the appeal, take the L, and move on. Bill hourly, court appointed. You're taking these cases. You choose to take these cases because he's conflict counsel. He's not in the public defender's office. Well, let's take a look at this on June 13th by order of the court. Within 20 days from the date of this order, so that's what, July 3rd-ish? I don't know if there are 30 days. I got to get my knuckles out to figure out if there are 30 days in June. Within 20 days of the date of this order, appellant shall serve an initial brief or alternatively file a response that shows cause why this appeal should not be dismissed for failing to timely serve an initial brief. If appellant fails to timely comply with this order, this case may be dismissed without further notice or opportunity to be heard. Uh-oh. That's not good. If she misses this date and her appeal gets dismissed, that's very bad for Sarah Boone. She deserves an appeal. She has a right to it. She wants one. She has a lawyer the state is paying to work on her case. So the court's going to give 20 days from June 13th. Well, let's take a look at the next order here by the court. That's not the right one. All right, let's take a look at this one. This one, as you can see, is July 1st, right about when that appeal was due, right? June 13th to July 1st. I don't know, is that basically 20-ish days? The motion for extension of time is granted. The appellant shall serve the initial brief within 60 days from the date of this order. I hereby certify that the foregoing is true copy of the original court order. So now we've extended it 20 days. Then we've extended it 60 more days. You know, Sarah Boone doesn't like this. She doesn't want to waste time. She wants to get this stuff done. 60-day extension after a 20-day extension is enough time. And I will say, her lawyer must be doing some kind of work, right? He must be billing at some sort to come up with different reasons as to why he needs this extension. The court agreed, grants the extension. If you notice from the first order, it said, this isn't going to be extended unless you give good cause. He provided good cause, and therefore it was extended. So let's take a look at what Sarah Boone thinks about this. What do you think, Sarah Boone? I'm going to give you guys a second in the chat. What do you think Sarah Boone feels about this? Is she going to complain? Is she going to be understanding? Is she going to come to the back of her lawyer and say, yep, he's working hard? Let's take a look. Comes now, Sarah Boone, appellant, and respectfully moves this honorable court to please provide status of her court-appointed appellate attorney, Joshua E. Adams, in addition to her inquiry as to the status of her pending appeal. So that's never good, that she doesn't know what's going on with her appeal. This was on 7/8. So this is after the second extension of time, June 13th, then July 1st. So after the second extension of time, she's like, what's going on? In support, the appellant states the following. Number one, an order was filed with the Ninth Judicial Circuit by the Circuit Court Judge Michael Kranick, appointing appellate counsel on December 18th, 2024. She's getting good at giving background in her motions, right? Not just jumping into it. Number two, court-appointed appellate counsel Joshua E. Adams has sent a single basic introduction via inmate messaging to appellant on February 27, 2025, asking if she had any information and to not hesitate to contact him with, it says. So we don't know if this is true, right? It's Sarah Boone. Could be true. It could be completely false. Who the heck knows? But one correspondence with your lawyer since December, what is that? She's writing this in July, 8 months, one message, basic info, and hey, call me if you need me. Now, I will say a lot of times appellate lawyers, they need to read through the transcripts. That can take forever. They need to issue spot. They need to figure out what your best arguments are. Then we usually will present that to a client and say, hey, here are the best arguments. Here's what we think. Is there anything you think absolutely should? If she says it should absolutely be this, and you're like, come on, that's not going to win, and you've got to have some tough conversations. Sometimes the client's like, I don't care if it's a worse argument. We have to make this argument. You're like, okay, it's your funeral. And you put that argument in. Regardless, you have some conversations. Even appellate lawyers that do a lot of reading, research, writing, and eventually an oral argument, if it gets there, it doesn't always get there. But one message can't be right. If it is right, that's a problem. And again, that December date is going to be important for when he got appointed. And we know he filed a motion for extension of time. Sounds like he didn't talk to Sarah Boone about that before filing it, which could also be a problem. You need to talk to your client about those things, if it's true, of course. Number three, appellant has attempted to contact Mr. Adams via inmate messaging 5 times and sent 2 handwritten letters, I bet those were nice, to his office in efforts to receive status of her appeal and to confirm receipt of her correspondence to ensure his representation was and is still active from no response of him. So she has reached out 7 different times. 7 different times. And from my perspective, that's a reasonable amount of times. That's not a crazy amount of times in 8 months. So she's reaching out less than once a month, basically. And again, this is assuming what she's saying is true. So we'll all hold that thought because I'm going to talk about if he really is screwing this up, what's the remedy? To the present date of this inquiry, appellant has not received any type of response or correspondence in any form or manner from Joshua Adams, nor has any of her 9 third-party representatives on her behalf via email and phone call, which go directly to his voicemail. So she wrote 7 times, and then 9 different times third-party representatives for Sarah Boone. I wonder who those are. And I can admit that'd be kind of annoying as a lawyer if 9 people or somebody's reaching out 9 different times. But I will tell you, okay, just to get real with you about what it's like being a lawyer, not every client is easy. Not every client is right. Not every client tells the truth. There are a lot of amazing clients, especially, on the criminal defense side. It can be very difficult. But there are frustrating clients. There are annoying clients. There are clients that want to talk every week, every day, and you have to manage expectations. You have to talk to clients at reasonable intervals. You have to give them updates on the case. It is their case. Respect their time. They're going through a very difficult time. Whether you think they did it or not, or the public likes them or doesn't, doesn't really matter. You sign up to be their lawyer, which this guy signs up to be a court-appointed counsel. And when you agree to do that, you have to talk to these clients. Again, this is the question I always get. Peter, would you consider representing Sarah Boone? No. Not the case for me. Not interested. Don't want to. I don't accept court-appointed cases. I don't sign myself up to be on a list that when I'm next on the list, I have to accept that case. Some lawyers do that. And if you do that and Sarah Boone ends up next on the list, you have to take that case. Now, from my perspective, I can take a client, I can fire them. They can fire me. And I think that's a good thing, that we're always working together and we have a common goal, especially in my personal injury cases, where it's contingent. Get paid at the end. Bigger the settlement, bigger the fee. I get a percentage. The more money they get, the more money I get. Common goals running parallel throughout a litigation, throughout an entire process. So yes, while it might be annoying, and I've had third parties reach out. I've had parents, I've had sisters, I've had friends, I've had girlfriends and boyfriends reach out to me on the client's behalf. Now it's limited the conversations you can have with them, but if it's like, hey, they've been trying to reach you and they can't reach you, that's a legitimate complaint. And if it was happening to me, I'd say, whoa, 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 we got a problem. What email are they sending it to? What number are they calling? What number are they texting? And we got to get to the bottom of it. And it's happened. And we're like, oh, you forgot the dot in the email, or there's actually no dot between my name and the email. Somebody asked, can you explain an appeal in Florida? Here's what I think you should do, because much, much, much better than I can appeal it. Go check out my video with Michael Ufferman, who is probably the best criminal appellate lawyer in Florida, and he's Charlie Adelson's appellate attorney. I did an entire video with him talking all about Florida appeals. Go check that out. And you'll learn everything you want to know and probably more about Florida appeals. Not a handwritten letter. Who typed this up for her? I don't know if somebody typed it up for her or if she has access now to a computer, a printer, and now she's able to actually do these things. And that could very well be what's happening here. Sarah is going for the Guinness World Record for most attorneys that quit. Chris, Peter, why can't you lawyers just be nice to Sarah? She's clearly not the problem. Maybe Lori Daybell can help. Chris, sometimes you ask unanswerable questions. I just can't answer this question. I'm sorry. All right, let's keep reading. Ongoing 7 months, appellant has received one message from her court-appointed attorney, Joshua Adams. Appellant has recently made aware, I think she means been made aware, by third-party representatives that the court issued an order on June 13th with a 20-day due date requiring an initial brief be filed or her appeal may be dismissed. Due to the complete lack of proper and effective communication from her court-appointed appellate attorney, the appellant's appeal is now in jeopardy. Okay, I was just noticing, so this must have been dated the 24th day of June. So I think I looked, I should look again maybe. I think I looked and I did not see a motion for extension of time. So this leads me to believe that there's some things going on. Okay. So yes, that was tongue in cheek, Alley Cat. Chris's comment was tongue in cheek. So now that this is on the 24th of June, which I can understand why she's worried, if there's just so many problems here. So she doesn't even know about the June 13th, 20-day deadline. She doesn't even know the judge is threatening to dismiss her appeal. That's a problem. That needs to not happen. Her lawyer needs to tell her when something like that happens, or you have too many cases, you shouldn't sign up for this, you just really can't do this. So it sounds like she didn't know about it. That's a major problem. Of course, she could be lying, but who knows? So then I'm starting to think now that this letter was put on the docket on July 8th, but she wrote this letter on June 24th, which is before the court's July 1st extension. I didn't see a motion filed by the lawyer. I just assumed he filed a motion because I saw the date at the top of this letter. I thought it was July 8th. So I assumed he filed that motion. Maybe he didn't file a motion for extension of time, but instead the court is taking Sarah Boone's own letter as a motion for extension of time, which when she's represented by counsel, you shouldn't be filing motions on your own accord. I see all kinds of problems here. All kinds of problems here. And I mean, the fact that she's finding out your appeal may be dismissed, that's a big deal. That's the only hope these criminal defendants have after they're convicted. Whatever you think about Sarah Boone, that's not how it should be. That's not how it should be at all. The failure of an appointed attorney to perform duties or communicate with their client cannot be held against the appellant. She's absolutely right about that. Dismissal of an appeal under these circumstances will be an obvious denial of her due process and effective assistance of counsel. I agree with her. Completely. I agree with her. Judge couldn't possibly dismiss her appeal, but what the judge don't know can't affect him. So if the judge didn't know, I think it might actually be a female judge, but what the judge didn't know, they can't say, okay, I'm just going to extend this appeal indefinitely. But now Sarah Boone's putting them on notice. I don't know what's going on. My lawyer's not even talking to me. What's going on here? The failure of appointed counsel to act cannot be imputed to the defendant to justify dismissal. That's a case that she cited, and she's absolutely right. And that's why the judge extended another 60 days, But if I was the judge, I would like reach out or send correspondence to this lawyer like, hey, you better be doing your job. Paragraph 7. Appellant further invokes Douglas v. California, which guarantees the right to counsel on a first appeal as of right. And Aders v. California, which outlines the duty of appointed appellate counsel to support the appeal or withdraw following proper procedures. Be careful what you wish for, Sarah. Neither of which have been followed here. Just wait. We've got more coming. Appellant respectfully requests this honorable court to please advise and take notice of these violations and either compel court-appointed appellate attorney Joshua Adams to fulfill his legal duties and communicate immediately, or appoint new counsel capable of necessary communication and representation and inclusion of the appellant. Again, dated the 24th day of June. Respectfully submitted, Sarah Boone. Peter, do you believe the attorneys do not answer because they're dreading answering her? Honestly, that's not a good answer for a lawyer. I don't have a lot of sympathy for lawyers if they would give me this answer. I'd say you're in the wrong line of business. If you can't answer a client's phone call, you shouldn't be doing this. Find something else to do. Dealing with people, dealing with clients, managing expectations, dealing with opposing counsel, with paralegals, that's part of the job. With clerks of court, with judges, we all have to do it. Communication is key. We have to be good at it. And even the best clients can be difficult at times because of the phase of life they're in when they call lawyers like us. Why is appeal law so different from regular trial law? You know, it's a good question. I don't know the answer to that. I think it's like you've done the work, you've put your hands on it, you've built something with this trial. An appeal is like to go back over it, read through everything, and do an academic study of was this fair? Was this just? Is this how we want it to be done? Is her appeal lawyer going to get in trouble for this? So I don't know. And we're about to read his motion to withdraw. And we're going to read through the reasons that he gives. And I'll give you my honest thoughts. He could be a very nice guy. He could be a very good lawyer. I don't think I know Joshua Adams. But I'm going to give you my honest, I don't care if it's Sarah Boone or your mom or somebody else that's involved in this. I'll give you my honest opinion of how a lawyer should act in these scenarios. Peter, the attorney filed an extension with the appeals court, not with the trial court. The clerk is filing them in both courts. Okay. So maybe that's why I didn't see it. I was just looking at the trial court level. I did not look at the documentation of the appeals court. Okay. If someone wants to send me that, if you guys are interested in continuing to follow this, I'm not necessarily planning on doing another video. If anybody has it, send it to me and I'll look at it right now. Send it to lawyeryouknow@gmail.com or send it to me on social media, and we will take a look at that and see what reasons he gave for getting this extension of time, which is the much more appropriate way to handle it than Sarah Boone's own letter. That's what I assumed happened. Charlotte, in my best Office Space voice, Peter, what's happening? I found you during Sarah Boone's trial and never left. Lawyer you know for life. I recognize that icon and that name. So Charlotte, I'm glad you're here. And I'm glad you've stuck around. All right, let's take a look at this. Motion to withdraw and request for appointment of new appellate counsel. This is filed by Josh Adams, who is Sarah Boone's appellate lawyer. So at first glance, it certainly seems like they are on the same page. I'm just telling John and Kelsey to let me know if anybody sends that motion for extension of time so that we can take a look at it here. All right. Comes now the undersigned court-appointed conflict counsel for the appellant and pursuant to Florida Rule of Appellate Procedure 9.140D and Rule 2.505 of the Florida Rules of General Practice and Judicial Administration, respectfully moves to withdraw as counsel and request that new counsel be appointed in support counsel states. Appointment and procedural posture. The appellant Sarah Boone was convicted in the Circuit Criminal Court and subsequently filed a notice of appeal. The undersigned was appointed by the lower tribunal as conflict counsel after conviction to handle the appellant's appeal pursuant to Chapter 27 of Florida statutes. A notice of appeal has been filed, and the undersigned has complied with the appellate rules by filing the necessary statement of judicial acts, directions to the clerk, and transcript designations. It seems like, based on what he's done, he's definitely billed. I shouldn't say definitely, he's probably gotten paid for some of his work. It also feels like he should be telling Sarah Boone when he does things like this. Somebody asked for me to zoom in. That's as much as I can zoom in, but don't worry, I'm going to read every word on this page. So it definitely sounds like this is something that you should be talking to Sarah Boone about as you're doing it, right? Good cause for withdrawal. Rule 9.140D provides that trial counsel may not be relieved of duties except with the approval of the lower tribunal on good cause shown. The undersigned, this is his reason why he wants to withdraw, is no longer practicing appellate work or accepting court-appointed appellate cases, which would make continued representation a hardship. So I've said this. If I've said this once, I've said it 1,000 times. I don't think lawyers should be forced into doing this. If lawyers don't want to handle this work, I don't think they should be forced into doing it. I don't want to do it, so don't force me to do it. I'm not on these lists. I don't want to do it. I don't want to do appellate work. Then I don't have to do appellate work, right? And I think that's how it should be. So when you're in a situation like this where he's like, I don't want to do appellate work and I'm not doing court-appointed work anymore. The problem is he signed up for it. He signed a contract. He's done some of the work. He's got paid for some of the work. The other problem is he's had this case now for 8 months, and now we're looking at, it's July 30th, assuming nothing's happened yet. She's got what, 30-ish more days before her appeal is due? He is causing a delay in Sarah Boone's appellate case. And from my perspective, I don't love it. As a lawyer, I'd like to just do the job for the client. Whether you like him or not, whether you like talking to him or about him or not, I would like to just do the work. If you sign up for it, you're getting paid for it. Do the work, finish the work. Additionally, this should be done in 30 days. So how much of a hardship is it really for somebody that's, and again, I don't know his background. Has he been practicing appellate law for a long time? I assume if you get on the court appointed list, you know what you're doing. And now with 30 days left for Sarah Boone, he is saying it's going to be a hardship for him to finish. I don't love that excuse. And again, I think lawyers should be able to practice the way they want to. I don't think he should be forced into it. But he signed up for it. And if I'm the judge, I'm not going to be real happy about this. Because now I'm going to have to appoint a new lawyer. He's going to have to look through all the transcripts. He's going to have to come up with his own issues. He's going to have to meet with Sarah Boone, talk to her, explain it to her. That's going to delay and extend the time. And she's already been convicted, and I get it. She doesn't have the same rights as she does as somebody who sits presumed innocent. But this is how cases drag. This is what clogs our court system. This is what wastes time and tax dollars. And every dollar that's been spent on Joshua Adams from the Florida taxpayers is a complete waste. Because now he's out. And he's been getting paid for 8 months. And he said, I filed this, that, and the other. I would hope he's reviewed the transcripts. That takes hours. I don't know. I don't love it. I don't love that as the reason at this point. Now, what you can do if you're looking like, Peter, what's he supposed to do? Take your name off the court-appointed list. Do not take any more court-appointed cases. Finish out the court-appointed cases you have. There's a big thing in the law, in the legal system. And judges look at it and they look to us lawyers like, don't screw the client. You know, people don't really care about lawyers. They don't feel bad for lawyers. How many hours we're working, how many clients we have. It's like, I've had lawyers say, Judge, I have another trial that week. I'm not going to be able to do it. They're like, you've got a lot of associates. You've got a big firm. Have one of them try it. Are you the only lawyer that can try a case in your firm? Or if somebody on the plaintiff side is like, Judge, I'm going to be in this case there, then don't take the case. If you're taking more cases than you can handle, don't take the case, but you got to be here. Some criminal lawyers that are paid, by the hour or the month or whatever, and they stop getting paid and they're like, Judge, I got to get off this case. Like, too bad, trial's next week. That's going to screw the client. Stay on the case and go ahead and try the case. And I think we always have to say, take everything that Sarah Boone says with a grain of salt. That doesn't mean that everything she's saying is true. It doesn't mean everything she's saying is false, right? So assuming arguendo that it's true. Somebody said, what if he's sick? So that's completely different. If there's a medical issue and he's sick and he can't handle it, that's better for Sarah Boone, right? You don't want somebody that is physically or mentally unable to represent you. So if he's sick, I get it. I completely get it. If he's sick, let him off, let somebody else take over. If he legitimately is like, I screwed up an appeal, I'm not good at appeals, I don't want to do it, sure, another good reason, right? Another good reason. And again, not hating on this guy, could be a completely great guy, could be a really great lawyer. I just don't love the reason and the timing of the reason. Need for appointment of successor counsel. Because this is a publicly funded appeal, the appellant is entitled to the continued assistance of counsel. Rule 9.140D directs that in publicly funded appeals, the lower tribunal should appoint the public defender or the Office of the Criminal Conflict and Civil Regional Counsel or private registry counsel to represent the defendant on appeals. The undersigned therefore requests that the court enter an order relieving current counsel of record and appointing appropriate successor counsel. Client contact information pursuant to Rule 2.505F. Counsel provides the appellant's last known contact information. There it is at the jail. So again, I think if I was the judge, I would let him off. The reason I would let him off is because Sarah Boone wants him off and he wants him off. And it's a situation where it seems like neither party really wants to do this. And if I was Sarah Boone, I would definitely say I want a lawyer who wants to do this. So even though it's going to delay the process, even though it's not ideal, even though I wish this lawyer would just finish it out, he's got 30 more days potentially to when the appeal is due, then of course there could be oral argument. It's not like the job ends, and I understand that. But to me, I think if I was going to guess how this is going to end, Sarah Boone is in fact going to lose lawyer number 11 and will be looking to meet lawyer number 12, who hopefully will provide the service that he should or she should, do the job, appeal the case for Sarah Boone. In my opinion, appeals process is like it is because the courts are usually putting out fires and these clients are not a harm to society because they are usually incarcerated. Does Florida do non-protunct? It sounds like this appeal screams this. I don't know. I don't know if I would say that this appeal screams non-protunct. So sorry I jumped on this late, and that was my very question. Sorry, did I miss the question? I don't know. Maybe it was while I was answering a certain question you put this out there. Do appeal lawyers have to meet? Hold on, let me pull this down because we're done with the document. Do appellate lawyers have to meet their clients as frequently as their regular trial lawyers? Can she represent herself in her appeal like at the trial? Great questions, Azam. So number one, no. Well, do they have to meet with their lawyer as often as a trial lawyer? I would say no, they don't have to. It's okay if they do. Every lawyer should meet with their client as often as is necessary to provide the best counsel you can and the best representation you can for that client in that situation. That's what I'll say. Usually, common practice, appellate lawyers meet with their clients a lot less, especially if they're incarcerated. Some are, some aren't. So usually you're doing a lot of reading, a lot of research, a lot of drafting, and you'll send a document to a client, review, and then we'll talk about it. Then you'll have a long meeting. Then you'll finalize it, and you have all these deadlines. You have page numbers. You have all these rules you have to follow in appellate rules. So you tell the client, I need your answer by the end of the week because we've got a filing deadline. So usually that's how it works. It's more, let's talk, let's meet, let's have a powwow, meeting of the minds. I'm going to do some research, reading, writing, put this together, send you a draft, give me your edits on the draft. I'm going to send you the final version. We need to get this filed. So you can imagine that you don't meet probably as much as the client wants or as much as you meet in a trial court setting. Can she represent herself in her appeal like a trial? Yes, she can. It's very ill-advised, even more so than trial. I would bet that the success rate of pro se appellate people, defendants, is even lower than that at trial. That sounds like a lawyer problem, not a me problem. I mean, I can understand if you had a really tough judge, if you have a judge that really wants to hold your feet to the fire, I could understand them saying no to this. But I don't know. All right, let's see what else we have here. Can she put an advert out for an appellate lawyer? Absolutely. An appellate lawyer can absolutely take this case pro bono, can represent Sarah Boone, can draft her appeal, work with her. If they get an oral argument, they can go and make the argument for her. We all know Sarah Boone's expectation for attorney communication is ridiculous. And I will say, criminal law is a little bit different. Like civil attorneys very rarely are also civil appellate attorneys. Criminal law, a lot of criminal trial lawyers do their own appeals. Sometimes they stay on, so they have a relationship already with the client. And sometimes that works out because they know the trial, they know the issues, they know what the client wants. And sometimes that can work out great. Sometimes that can work out great. When did he decide he didn't want to do appellate work? After reading Sarah's transcript, Patricia, it's a legit question. Like, when did you decide this, man? Because it had to be after you were on the court-appointed list and accepting appeals. How many do you have that you're bouncing off of? Some legitimate questions that I think the judge could ask. All right. It doesn't sound like we got that motion sent over to us. All right. Peter, will he have to pay back what's been paid today? Usually not. If he did the work and it's hour and he submitted the bill and the bill got paid, usually that stands. Usually that is what it is. All right. That's it. Not a ton for today, right? A little bit of a shorter video. I thought this was something else when all of you guys sent it to me. And as usual, what you guys asked for is what we're going to talk about on this channel. Make sure you hit that like button. Make sure you're all subscribed. Adelson's coming up, a really fun podcast that I recorded for this week. I am very excited for you guys to see it and hear it. A guest we're welcoming back that we haven't seen in a little while to talk about an overarching issue and some things trickling out in a case that many of you are familiar with. Rebecca said, that's okay, Peter. I beat you with a Cowboy team that had a literal poop record. I had a legit question as well. Go Cowboys. Let's go Fantasy League. Yeah, we've got to set that up. John and Kelsey, put that on our list. Early August, we've got to set that up. All of my fantasy leagues are coming to a head right now, and I'm so far behind. I haven't looked at any of it because of summer. We've just been so busy traveling. I have one more trip planned still. And I've been following so many cases that I haven't been able to follow fantasy football as much as I used to, but we are definitely going to do fantasy football. So make sure everybody keeps a lookout for that. We do a membership league every year. Join the membership if you want a chance to do a fantasy football league with us. Peter, what do you think Sarah believes is necessary communications? She would probably say weekly or whenever she reaches out, right? That's probably what she would say, but I'm totally guessing. At reasonable intervals is basically what the law is. And from my perspective, appellate cases, monthly would probably be a lot, But whenever you need to, whenever something big happens, whenever you file a motion, whenever you get something in, whenever you draft something big, whenever you file something, whenever you ask for an extension, she should be communicated when that happens. She really should. Oh, great. Aaron, appellate attorney in Missouri. Thank you, Aaron. I speak with most of my clients once every couple of weeks, but I block off time in my calendar specifically to send messages with updates or requests. So here's what I'll say. Based on your representation, I would consider communicating with client your calls and your messages. So you're frequently communicating with clients. And I would guess, and this is again just totally guessing, that your clients don't usually complain about communication, because this is more than I would say your average appellate attorney works. And I would say that should be considered a benefit to clients, a client service, a reason they should hire a lawyer, one lawyer over another, because client communication is incredibly important. That's something we preach. That's something all of our associates, if a client has that complaint, it doesn't go well with me, and we'll have a conversation. You have to stay in communication. You can't, always change the facts. You can't always make every client happy if they want the world. Sometimes it's impossible. The facts are what they are. We do the best job we can, but you can always control communication. Always. When does Donna's trial start? I think, is it August 18th? I don't know if that's jury selection or the trial starting. Let's take a look at that real quick. It says Tuesday, August 19th. So I am starting a week-long trial on August 18th, but I think I will be able to catch a lot of hers on 2 or 3 times speed. I know a lot of the facts already. And we'll see what our recap is like, at least the first. If she's starting on Tuesday, I'll be done by Friday. So at least the first 4 days may be difficult. Oh, somebody said August 22nd. So are they picking the jury maybe the first week? That would be awesome if jury selection was the first week. So that's all I'm missing while I'm in my trial. That would be awesome. How would an appellate attorney find anything to appeal in Sarah's case? You can always find something to appeal. Always, always, always. And I would think that one of the first things an appellate attorney is going to look at is how much did it damage Sarah Boone's case that the judge found that she constructively waived her right to counsel, number one. And then number two, when she finally got a lawyer to take the case pro bono, refused to grant a continuance. Those, I think, are the two biggest appellate issues that pop into my mind for what I know about Sarah Boone's case. And we'll see. Rebecca, love you, chat, you know. Awesome. Thank you, Rebecca. Thank you for everybody joining us. That's all we got. Till next time, I am almost out of here. Let me tell you right now in the chat, tell me, do you think this is Sarah Boone's last lawyer? Do you think 12 is the end of the road? Or do you think lucky number 13 is coming eventually? I honestly have no idea. I'd always bet 12 is the last one, but who the heck knows? All right, peace out, everybody. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a pase you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.